Conflict of laws is a part of the municipal law of a state which directs its courts and administrative agencies when confronted with a legal problem involving a foreign element, whether or not they should apply foreign law or foreign laws. From Paras. That part of the law of each state or nation which determines whether, in dealing with a legal situation, the law of some other state or nation will be recognized, given effect, or applied. The law concerning the rights of person within the territory and dominion of one nation by reason of acts, private or public, done within the dominion of other nation. Hilton versus Guyot, 159 U.S. 113, June 3, 1895. Fundamentally a problem of choice of law between foreign law and local or municipal law by the foreign court, with local or municipal law as its starting point. That's from Agpalo. Conflict of laws case. Any case involving facts occurring in more than one state or nation that must choose between the laws of different states or countries in deciding the case. Sempio, D. Handbook on Conflict of Laws, 2004. What does state mean in conflict of laws? It includes not only foreign sovereign countries or state, but also political subdivision of states or countries which have their own legal systems. Functions of private international law. G.C. Cheshire states the scope and threefold functions of conflict of laws in the following manner. Number 1. Prescribes the condition under which a court or agency is competent to entertain proceedings with foreign elements. Number 2. Specifies the circumstances in which foreign judgment will be recognized as valid and binding in the forum. Number 3. Determines the particular system of law for each class of cases to ascertain the rights of parties. Paras. Elements of conflict of laws. Number 1. Legal problem or case involving a foreign element, and, note, foreign element, factual situation cutting across territorial lines affected by diverse laws of two or more states. Number 2. Primary function is to determine whether the law or judgment of other states will govern, and if so, the extent of its recognition or application in the forum. Kokya and Agiling Pangalangan. Remedies of conflict of laws. The enforcement of rights accrued in a foreign country in the form of an action filed in Philippine courts by a citizen or aggrieved person, and number 2, recognition and enforcement of foreign judgment. Agpalo. Public international law versus private international law. Public international law as to nature or character, international character. Private international law, national, municipal, or local in character. As to persons involved, governed states and entities internationally recognized or possessed of international personality, exceptionally individuals too. Private international law governs private individuals or corporations. As to transactions involved, public international law recognizes transactions in which sovereign states are interested. Public international law assumes control over transactions which are strictly private in nature. As to remedies applied, public international law, in case of violation of international law, the state may resort to diplomatic protest, negotiation, arbitration, or adjudication by filing cases before international tribunals, or may even resort to use of force or go to war. Public international law, all remedies are provided by municipal laws of the state, such as resort to courts and administrative tribunals. Sources. Direct sources. Letter A. Treaties and international conventions. B. Constitutions. C. Codifications and statutes. D. Judicial decisions. And E. International customs. Indirect sources. A. The natural moral law. And B. The writings and treatises of thinkers, famous writers, and jurists on the subject, among others. History and development. Early period. Theory of statutes. Conflicts resolved by classifying the issues based on real, personal, and mixed statutes. That classifications were overlapping. 16th century, number 2. Customs used for resolving conflicts. Number 3. 17th century. Doctrine of comitas, gentium. Relied on the theory of state sovereignty, denied any legal obligation to apply foreign law unless it was made out of courtesy and expediency. Number 4. Beginning of codifications. Jurisdiction. General rule. It is the right of a state to exercise authority over persons and things within its boundaries. Exceptions to jurisdiction within boundaries. Judicial jurisdiction. Number 1. Judicial jurisdiction. Legal authority of a state to exercise authority through its courts or agencies in hearing and adjudicating cases. Number 2. Legislative jurisdiction. The power of a state to regulate or control through rules of law the interest of persons in a thing, event, or situation. Steps in dealing with problem in conflict of laws. Determine whether the court has jurisdiction over the case. If it has no jurisdiction, the case should be dismissed on that ground. If it has jurisdiction, the court will determine whether it should assume jurisdiction over the case or dismiss it on the ground of forum non-convenience. Once the court has determined whether it has jurisdiction over the case, it will next determine whether to apply the international law. That's number 2. Types of judicial jurisdiction. Jurisdiction over the person. The competence or power of court to render a judgment that will bind the parties to a case. Number 1. Jurisdiction over the person of the plaintiff is acquired from the moment he invokes the aid or power of the court by instituting of action through proper pleading. Jurisdiction over the person of the defendant is acquired through letter A. Voluntary appearance, where action is in personam. Rules of Court, Rule 14. Coercive process through personal or substituted service of summons, where actions is in personam. Rules of Court, Rule 14, Section 6 and 7. Letter C. Constructive service by publication, where the identity or whereabouts of the defendant is unknown. Rules of Court, Rule 14, Section 14. Extraterritorial service, Rules of Court, Rule 14, Section 15 and 16. And service upon a foreign private judicial entity which has transacted business in the Philippines through its resident agent, designated in accordance with law for that purpose, or if none, the government official designated by law to that effect, or any of its officers or agents within the Philippines. If the foreign private juridical entity is not registered to do business in the Philippines, service may be coursed through any of the following means. By personal service coursed through the appropriate court in the foreign country with the assistance of the DFA. Next, by publication in newspapers of general circulation in country where defendant may be found, and serving a copy of the summons, court order at the defendant's last known address by registered mail. Third, by facsimile or other recognized electronic means that could generate proof of service. Fourth, by such other means as the court may direct in its discretion. Jurisdiction over the rest. Jurisdiction over the particular subject matter in controversy, regardless of the persons who may be interested therein, that's paras, results from a seizure of property under a legal process or institution of legal proceedings where the court's power over the property is recognized and made effective, referred to as in rem jurisdiction, in contrast to in personam jurisdiction, which binds only the parties and their successors in interest. A personal action, however, may be converted to in rem by attachment of property, among others. Quasi in rem jurisdiction affects only the interest of particular persons in the thing. Long Arm Statute, a law that allows the plaintiff to make a claim against a defendant who is in who is a non-domiciliary of a state, provided there are minimum contacts with a forum to justify jurisdiction over him. Long Arm Statute, a law that allows a plaintiff to make a claim against a defendant who is a non-domiciliary of a state, provided there are minimum contacts with a forum to justify jurisdiction over him. Jurisdiction over the subject matter. It is the power of the court to hear and determine cases of the general class to which the proceedings in question belong. Note, in the Philippines, jurisdiction over the subject matter is conferred by law. Example, the Constitution and the Judiciary Reorganization Act as amended, Judiciary Act of 1948, BP 129 as amended by RA 7691. In conflict of laws, the court must consider the laws conferring jurisdiction and the possible enforceability of its decision in foreign states, subject to the rights of said states. Test of jurisdiction, whether the law vests upon the tribunal the power to enter upon the inquiry. Basic principle underlying all rules of jurisdiction. A state does not have jurisdiction in the absence of some reasonable basis for exercising it, whether the proceedings are in rem, quasi in rem, or in personam. To be reasonable, the jurisdiction must be based on some minimum contacts that will not offend traditional notions of fair play and substantial justice. Minimum contacts test and fundamental fairness test. To bind a defendant absent from the territory of the forum to a judgment in personam, due process requires that he should have certain minimum contacts with it in the maintenance of the suit does not offend traditional notions of fair play and substantial justice. International Shoe Co. Corporation versus Washington. Note, for in rem and quasi in rem, due process is satisfied when defendant is given adequate notice and opportunity to be heard by service of summons by publication. Points to remember for jurisdiction. In choosing a particular forum, the plaintiff accepts the forum's entire judicial machinery, its benefits and burdens. Number 2. The jurisdiction of the court continues even if the defendant leaves the state of the forum prior to the final determination of the action against him. Number 3. The parties to a contract may stipulate on the foreign law to govern disputes arising from the contract. Number 4. The parties may stipulate on a jurisdiction clause, a contract clause which provides that any dispute arising from the contract shall be tried before the competent or specific court of a particular state. Number 5. A court, in assuming jurisdiction over the case, may apply the internal law of the forum, lex fori, or the law of some other states. Number 6. The case may be dismissed for a lack of jurisdiction of the court or its refusal to assume jurisdiction over the case pursuant to forum nonconvenience. Principle of forum nonconvenience. A court's discretionary power to decline to exercise its jurisdiction where another court may more conveniently hear a case. Under the rule of forum nonconvenience, a Philippine court or agency may assume jurisdiction over the case if it chooses to do so, provided that the Philippine court is one of which the parties may conveniently resort to. Number 2, that the Philippine court is in a position to make an intelligent decision as to the law and the facts. And 3, that the Philippine court has or is likely to have power to enforce its decision. Okay. Instances where forum nonconvenience may be invoked. A court, though it has jurisdiction over a case, may decline to exercise it in view of any of the following particular practical reasons. Number 1, evidence and witness may not be readily available in the forum. Number 2, court dockets of the forum may already be clogged, and permitting additional cases would hamper the speedy administration of justice. 3. Belief that the matter can be better tried and decided in another jurisdiction, either because the main aspects of the case transpired there or the material witnesses have their residence there. Number 4. To curb the evils of forum shopping. Number 5. Forum has no particular interest in the case. Number 6. Other courts are open and the case may be better tried in said courts. Number 7. inadequacy of the local judicial machinery, and number 8, difficulty of ascertaining the foreign law applicable. Note, the court will not dismiss the case under the doctrine unless the plaintiff has another forum open to him. The doctrine should generally apply only if the defendant is a corporation. If the defendant is an individual, the proper forum might not acquire jurisdiction over him. Example, he may not be residing there, leaving the plaintiff without any remedy. Justification for the application of internal law to conflict of laws cases, lex fori. When the law of the forum expressly so provides in its conflicts rules. Letter A. Law governing property transaction, Civil Code. Reason. Article 16 of the new Civil Code mandates the application of lex situs or lex re cite to all properties, whether real or personal, found and located here. Letter B. Law governing the order and amount of successional rights, intrinsic validity of testamentary provisions, and capacity to succeed, Civil Code, Article 16, Paragraph 2. Laws governing property relations of marriage, Family Code, Article 80, and laws governing revocation of wills, Civil Code, Article 829. Number 2. When the foreign law has not been properly pleaded and proved. Reason. Our courts cannot take judicial notice of foreign laws, so that if the proper foreign law is not pleaded in the complaint or petition or in the answer or any other responsive pleading and is not proven as a fact, the court has the right to presume that the applicable foreign law is the same as the internal or domestic law of the forum and should therefore apply the latter law. Adong versus Chuang Seng Gi, GR number 18081, March 3, 1922. Number 3. When the case involves any of the exceptions to the application of the proper foreign law. Letter A. The application of foreign law runs counter to the sound and established public policy of the forum. Example, in census marriage, joint will. Kinds of public policy as to extent of operations. Number 1. Operates no matter where the event or transaction takes place. And 2. One which operates only where the event or transaction takes place in the forum and is not offended if the transaction is completed abroad. Note, courts may use public policy to A. Refuse to entertain the case and dismiss it without prejudice because its enforcement is against public policy. B. Entertain the case and apply domestic law. C. Entertain the case but invoke its own public policy to apply the forum's domestic law. B. The foreign law is contrary to the almost universally concealed principles of morality or contra bonus mores. Example, foreign laws recognizing prostitution. Letter C. The foreign law is penal in character. Crimes committed in foreign countries are violations of penal laws of those countries and cannot be prosecuted here, especially as we follow the principle of territoriality in criminal law. A penal clause in a contract entered into abroad may be enforced here because such is not criminal but civil in nature, providing only for liquidated damages. Note, enforcement of foreign penal laws must be distinguished from their recognition. A state may recognize foreign penal laws for various purposes, though it will not directly enforce such laws in its jurisdiction. Letter D. The foreign law involves procedural matters. There are no vested rights in rules of procedure. Hence, a party to an action must submit himself to the procedural formalities of the forum, except when the law is both substantive and procedural. Example, Statute of Frauds. Reason. If foreign procedural laws were to be applied, it would involve a making over of the machinery for the administration of justice in the forum. Procedural issues are governed by the foreign law so as not to unduly burden or complicate the task of the court with the study of uncommon peculiarities and refinements of another legal system. Kokia. E. Foreign fiscals or administrative laws. Example, tax law, local rates, etc. Note, a sovereign has no legal duty to assist foreign governments in the financing of their activities. F. The application of foreign law involves injustice or injury to the residents of the forum, or endangers the foreign relation or vital interest of the state. And letter G, the case involves real or personal property located in our country. Proof of foreign law. General rule. Courts do not take judicial notice of foreign laws. If alleged to apply, it must be proved according to the following rules. Number 1. Written law. By official publication. B. Copy attested by officer having legal custody thereof. If the record is not kept in the Philippines, a certificate with seal from the Secretary of the Embassy, Legation Council, Legation, Consul General, Consul, Vice Consul, Consular Agent, or any officer in the foreign service of the Philippines stationed in a foreign country to the effect that said officer has custody is required. Rules of Court. Rule 132. Letter C. A published treatise on the subject law, provided that the court takes judicial notice of the competence of the writer or evidence is introduced to establish the author's competence. Rules of Court 130. Unwritten law. By oral testimony of expert witnesses, or note, the testimony of an expert witness may be allowed to prove a foreign law. Section 25, Rule 132 of the Rules of Court does not exclude the presentation of other competent evidence to prove the existence of a foreign law, as Chavez Limited versus CAGR number 128803, September 25, 1998. B. By printed and published books of reports of decisions of the country involved, if proved to be commonly admitted in its courts. Rules of Court, Rule 130, Section 45. Instances exempting the application of internal law to conflict of laws cases. A foreign sovereignty, diplomatic official, or public vessel or property of another state is involved. Number 2. The state accepted a limitation upon its jurisdiction over certain persons or things of another state by a treaty. Salonga, Private International Law, 1995. Number 3. Foreign law has been pleaded and proved. Rules of Court, Rule 132. Effect of failure to plead or prove foreign law. Defendant may move for demurrer to evidence if plaintiff cause of action rests on unproven foreign law, resulting in no cause of action to the plaintiff's case. If the defense rests on unproven foreign law, the defense fails. Aquino, Elements of Private International Law, 2006. Number 2. The case will not be dismissed. The doctrine of processual presumption will become operative because the court has no reason to displace the basic law when the claim applicable foreign law is not proved. Processual presumption of law. When the proper foreign law has not been properly proved, the court of the forum may presume that said foreign law is the same as the law of the forum that said court can now apply. It applies when the foreign law is not alleged, or if alleged, is not proved. A Philippine court may take judicial notice of a foreign law, as when the laws are already within its actual knowledge, such as when they are well and generally known, or they have been actually ruled upon in other cases before it and none of the parties concerned claim otherwise. PCIB versus S. Colin, GR numbers L 27860 and 27896, September of 1975. Choice of law. Questions that choice of applicable law seeks to answer. Number 1. What legal system should control a given situation where some of the significant facts occurred in 2 or more states? And number 2. To what extent should the chosen system regulate the situation? Note, foreign law has no extraterritorial effect, and any exception to this right must be traced to the consent of the nation. Theories in justifying the application of foreign law in conflict cases. Theory of comity. The application of foreign legal systems in cases involving foreign element is proper. Otherwise, the non-application would constitute a disregard of foreign sovereignty or lack of comity toward other states. Comity, it is the recognition which one nation allows within its territory to the legislative, executive, or judicial acts of another nation, having due regard both to international duty and convenience and to the rights of its own citizens, of other persons who are under the protection of its laws. Paras. Two principles upon which theory of comity rests. A. Comity based on reciprocity. B. Comity based on persuasiveness of a foreign judgment. Note: a foreign final judgment or final order is presumptive evidence of a right as between the parties and their successors in interest by subsequent title, and may be repelled by evidence of a want of jurisdiction, want of notice to the party, collusion, fraud, or clear mistake of law or fact. Rules of Court, Rule 39. Vested rights theory. Courts enforce not the foreign law or foreign judgment, but the rights vested under such law or judgment. Thus, rights acquired in one country must be recognized and legally protected in another country. The foreign will not apply the foreign law, but will simply recognize the right vested by said law. Local law theory. This involves the appropriation of a foreign rule by the state of the form and transforming it into a domestic rule. A foreign law is applied because our own law, by applying a similar rule, requires us to do so, as if the foreign law has become part of our own internal or domestic law. Illustration: Article 16, Paragraph 2 of the Civil Code requires the application of the national law of the deceased in the matter of his testate or intestate succession. Theory of justice. Caver's principles of preference. Choice of law should be determined by considerations of justice and social expediency, and should not be the result of mechanical application of the rule or principle of selection. Kokia. The defect in this theory is that different persons have different ideas of what is just. Harmony of laws theory. Identical or similar problems should be given identical or similar solutions, thus resulting in harmony of laws. The application of the same or similar solution prevents the bad practice of form shopping. Note: the foregoing theories do not mutually exclude another. Perhaps the truth may be found in their combination. Paras. Nature, composition, and characterization of conflict rules. Conflict rules. A provision found in our own law which governs a factual situation possessed for a foreign element. It is usually expressed in the form of an abstract proposition that a given legal question is governed by the law of a particular country, which may be an internal law or the proper foreign law, to be ascertained in a manner indicated in the provisions. Ordinary internal rules versus conflict rules. Ordinary internal rules authorize, command, or prohibit certain mode of conduct. Example: Article 796 of the Civil Code. Its legal effects are immediately indicated. Example: express provision. Conflict rules decides on which law or jurisdiction will give the final solution to the question. Example: Article 16, Paragraph 1 and Article 17, Paragraph 2 of the Civil Code. Two kinds of conflict rules. Number 1. One-sided rule indicates when Philippine law will apply. Example: Article 15 and Article 818 of the Civil Code only apply to Filipinos. Number 2. All-sided or multilateral rule indicates whether to apply the local law or the proper foreign law. Example: first paragraph of Article 16 and Article 17, Article 1763, and Article 1039 of the Civil Code. Note: Justice Sempio D. observes that while Article 15 of the Civil Code applies only to Filipinos and is actually a one-sided rule, the Supreme Court has given it a multilateral application when it held that foreigners in their status and legal capacities are governed by their national laws. Gibbs versus Government, GR number L 35694, December 23, 1933. The nationality theory has been applied by the Supreme Court even to persons who are citizens of countries following the domicile theory. Part of conflict rules. Object of the factual situation. The set of facts or situation presenting a conflict problem because there is a foreign element involved. Legal consequences of the point of contact or connecting factor. Number 2. The law of the country with which the factual situation is most intimately connected. Characterization of or doctrine of qualification or classification. Characterization is the process of deciding whether or not the facts relate to the kind of question specified in a conflict rule. Saudi Arabian Airlines versus CA, GR number 122191, October 1998. Characterization is defined as the process by which a court at the beginning of the choice of law process assigns a disputed question to an area in substantive law, such as torts, contracts, family law, or property, Kokia. The law chosen should be applied only insofar as it brings about the good it was intended to bring. The selected proper law is applied to the factual situation to decide, number 1, legal consequences resulting from the situation, or 2, interest created in the thing in question. Steps in characterization. Number 1, the determination of the facts involved. Number 2, the characterization of the factual situation. 3, the determination of the conflicts rule which is to be applied. Number 4, the characterization of the point of contact where the connecting factor. Number 5, the characterization of the problem as procedural or substantive. 6, the pleading and proving of the proper foreign law. And number 7, the application of the proper foreign law to the problem, paras. Note, only steps 2 to 5 concern themselves with characterization proper. Okay. Rules on characterization of procedural and substantive rules. General rule. If an issue is substantive, apply foreign law. If it's procedural, apply the foreign law or lex fori. Questions of evidence. Procedural. Number 2, statute of fraud. Substantive if the law forbids the obligation. Example, void contract. Letter B. Procedural if the law forbids the enforcement of the obligation. Example, unenforceable contracts. Article 1403 of the Civil Code. Number 3. Borrowing statutes and statutes of limitation. Borrowing statutes directs the forum to apply the foreign statute of limitations to the pending claims based on a foreign law. Statute of limitations specificity test. Limitation is substantive when it is directed at the newly created liability, warranting a qualification of the right. Limitation is procedural if it operates to bar only the legal remedy without impairing the substantive right involved. The characterization of a statute of limitation into procedural or substantive becomes irrelevant when the country of the forum has a borrowing statute, which has the practical effect of treating the foreign statute of limitation as one of substantive law. Note, a law on prescription is sui generis in conflict of laws, as it may be viewed as procedural or substantive, depending on the characterization given. Cadalin versus Poe, GR number 104776, December 1994. The modern trend is to consider the prescriptive periods of the statute of frauds that the parties had in mind at the time of transaction took place. Dépicage, from the French dissiper. I don't know if that's how it was supposed to be pronounced, meaning to dissect. The different aspects of the case involving a foreign element may be governed by different systems of law. Lipstian, General Principles of Private International Law, allows the other relevant interests of the parties to be addressed and permits the courts to arrive at at a functionally sound result without rejecting the methodology of the traditional approach. Proposed solution to the problem of characterization. The Lex Fori solution general rule. The facts and issues are characterized based on form's own law. Thereafter, the foreign or domestic law is applied to the Lex Fori-based characterization. Reason. Lex Fori determines characterization because of practical necessity. Exception. When Lex Fori characterization will result in clear injustice, Lex Fori characterization will not apply. Number 2. The Lex Causae solution. The characterization will depend on the governing law. Number 3. The Analytic Jurisprudence and Comparative Law solution. The court determines the common patrimony of juridical concepts and employs universal or quasi-universal characterization. Number 4. The double characterization solution. It couples the Lex Fori and Lex Causae solution. Number 5. Substance versus procedure principle. Matters of procedure, governed by the law of the form where the case is filed. Matters of substance, governed by the law of the country where the action arose. Number 6. Center of gravity doctrine. Application of the law of the jurisdiction which has the most significant relationship to or contact with the event, parties, and issues. Number 7. The autonomous theory. Form considered the characterization of the country referred to in Lex Causae. Totality theory, or number 8. Totality theory. Determines the intended law of the parties and applies the characterization given by the intended law. Personal law. The law which attaches to a person wherever he may go and generally governs his status, capacity, condition, family relations, and the consequences of his actuations. It allows courts to exercise jurisdiction or determine the governing choice of law, rule on a specific situation or transaction involving a person whenever he may be. Different theories of personal law. The nationality theory or personal theory. The status and capacity of a person is determined by the law of his nationality or national law. Note, the Philippine follows the nationality theory. Number 2. The domicile theory or territorial theory. The status and capacity of a person is determined by the law of his domicile. Number 3. The situs or electric theory. The particular place or situs of an event or transaction is generally the controlling law. Jurisdiction of personal law. Professor R.H. Graveson writes that the idea of a personal law is based on the conception of man as a social being, so that those transactions of his daily which affect him most closely in a personal sense, such as marriage, divorce, legitimacy, many kinds of capacity, and succession, may be governed universally by that system of law most suitable and adequate for the purpose. Nationality or personal theory or lex nationali. It is the theory by virtue of which the status and the capacity of an individual are generally governed by the laws of his nationality. The personal law of an individual is his national law. This theory is adopted mostly by civil law countries, like the Philippines, where the identity and legal position of their citizens are guaranteed by a consistent application of their national laws on status and family relations whenever they may go. Laws relating to family rights and duties or to status, condition, and capacity of persons are binding upon citizens of the Philippines even though living abroad, as Civil Code Article 15. Nationality, it refers to the membership of a political community, one that is personal and more or less permanent in conflict of laws. Nationality and citizenship are used interchangeably. Status refer to the place of an individual in society and consist of more or less permanent personal qualities and relationships with which the state and community are concerned. Capacity is a part of one's status and is the sum total of one's rights and obligation. Two kinds of capacity: juridical or passive capacity, the fitness to be the subject or legal relations; capacity to act or active capacity, the power to do acts with legal effects. Acquisition of nationality. Number 1, birth. Natural born citizens are citizens of the Philippines from birth without having to perform any act to acquire or perfect citizenship. A. Jus soli, nationality of the state where he is born. B. Jus sanguinis, nationality of the parents. Naturalization. Number 2. It is the process of confirming on an alien the citizenship of another country by any of the means provided by law. Modes of naturalization. Direct naturalization. Number 1. Judicial process. Commonwealth Act number 475 as amended RA 530. Second, legislative process. Philippine citizenship conferred by Congress. Third, administrative process. The Administrative Naturalization Law of 2000 or RA 939139. A special committee is created to approve, deny, or reject application for naturalization filed with said committee. B. Derivative naturalization. Number 1. Wife of naturalized husband. Number 2. Minor children of naturalized parents. Number 3. Alien wife of a natural born or naturalized citizen. If a woman repatriates, her repatriation does not carry with it the repatriation of the child, as the minor was never a Filipino previously. Villahermosa versus Commissioner of Immigration, GR number L 1663, March 31, 1948. If instead of repatriation, the widow had automatically regained Philippine citizenship, the nationality of her minor child would follow hers. Talarok versus Uy. Effect of naturalization. A. Minor born before naturalization. Born in the Philippines, Filipino. Born outside the Philippines, residing in the Philippines at the time of parents' naturalization, Filipino. Number 2. Residing outside the Philippines of the time of parents' naturalization, Filipino only during his minority unless he resides permanently in the Philippines when he is still a minor, in which case he will continue to be a Filipino citizen even after becoming of age. B. Minor born after naturalization. Born in the Philippines, Filipino. Born outside the Philippines shall be considered a Filipino citizen unless, within 1 year after reaching the age of majority, he fails to register himself a Filipino citizen in the Philippine consulate of the country where he resides and to take the necessary oath of allegiance. In case of children already of age at the time of parents' naturalization, not Filipino unless they themselves be naturalized. The 1997 Constitution provides that citizens of the Philippines who marry aliens shall retain their citizenship unless by their act or omission they are deemed under the law to have renounced it. If she became a widow before the effectivity of Commonwealth Act 63, which is on October 21, 1963, she immediately reacquires Philippine citizenship. If she became a widow on or after October 21, 1963, she has to repatriate herself, otherwise she remains a foreigner. Villahermosa versus Commissioner of Immigration. Citizenship Retention and Reacquisition Act of 2003, RA 9225, August 29, 2003. Number 2. Declaration of Policy. It is hereby declared the policy of the state that all Philippine citizens of another country shall be deemed to have lost their Philippine citizenship under the conditions of this act. Section 3. Retention of Philippine citizenship. Any provision of law to the contrary, notwithstanding natural-born citizenship by reason of their naturalization as citizens of a foreign country, are hereby deemed to have reacquired Philippine citizenship upon taking the oath of allegiance to the Republic. Natural-born citizens of the Philippines who, after the effectivity of this act, become citizens of a foreign country shall retain their Philippine citizenship upon taking the aforesaid oath. Section 4. Derivative citizenship. The unmarried child, whether legitimate, illegitimate, or adopted, below 18 years of age, of those who reacquire Philippine citizenship upon effectivity of this act shall be deemed citizens of the Philippines. Section 5. Civil and political rights and liabilities. Those who retain or reacquire Philippine citizenship under this act shall enjoy full civil and political rights and to be subject of all attendant liabilities and responsibilities under existing laws of the Philippines and the following conditions. Number 1. Those intending to exercise the right of suffrage must meet the requirements under Section 1 of Article 5 of the Constitution, Republic Act 9189, otherwise known as the Overseas Absentee Voting Act of 2003 and other existing laws. Number 2. Those seeking elective public office in the Philippines shall meet the qualifications for holding such public office as required by the Constitution and existing laws, and at the time of the filing of the certificate of candidacy, make a personal and sworn renunciation of any and all foreign citizenship before any public officer authorized to administer an oath. In Sobehana Condon versus Comelec et al., GR number 198742, August 10, 2012, the Supreme Court ruled that Section 5, number 2 of Republic Act of 9225 compels natural-born Filipinos who have been naturalized as citizens of a foreign country but who reacquired or retained their Philippine citizenship, number 1, to take the oath of allegiance under Section 3 of Republic Act 9225, and number 2, to those seeking elective public office says in the Philippines to additionally execute a personal and sworn renunciation of any and all foreign citizenship before an authorized public officer prior or simultaneous to the filing of their certificates of candidacy to qualify as candidates in the Philippine elections. The rule applies to all those who have reacquired their Filipino citizenship without regard as to whether they are still dual citizens or not. It is a prerequisite imposed for the exercise of the right to run for public office. Note, however, in McKilling versus Comelec, in April 2013, petitioner repatriated under RA 9225 and made his oath of allegiance and renunciation of U.S. citizenship. Thereafter, he used his U.S. passport. The Supreme Court ruled that the use of the U.S. passport is a positive declaration that he is a U.S. citizen, reverting him back to the status as if no oath of renunciation was made, thus rendering him disqualified to run for public office. Number 3, those appointed to any public office shall subscribe and swear to an oath of allegiance to the Republic of the Philippines and its duly constituted authorities prior to their assumption of office, provided that they renounce their oath of allegiance to the country where they took that oath. Number 4, those intending to practice their profession in the Philippines shall apply with the proper authority for a license or permit to engage in such practice. And number 5, that right to vote or be elected or appointed to any public office in the Philippines cannot be exercised by or extended to those who are candidates for and are occupying any public office in the country of which they are naturalized citizens and or b. are in active service as commissioned or non-commissioned officers in the armed forces of the country which they are naturalized citizens. Problems in applying the nationality principle in dual or multiple citizenship. It arises from the concurrent application of jus soli and jus sanguinis at birth, or from a refusal of certain states to accept a full application of the doctrine of expatriation from marriage or from a formal and voluntary act. Number 1, in matters of status, a person is usually considered by the forum as exclusively its own national. His additional foreign nationality is disregarded. Number 2, in case litigation arises in third country, the law most consistently applied is that of the country of which the person is not only a national but where he also has his domicile or habitual residence, or, in the absence thereof, his residence. Theory of effective nationality. A third state shall recognize exclusively in its territory either the nationality of the country of which one is habitually and principally a resident, or the nationality of the country with which in the circumstances one appears to be in fact most closely connected. Hague Convention of Conflict of Nationality Laws. Article 5. Multiple citizenship arises due to: 1. Naturalized citizens' failure to comply with certain legal requirements in the country of origin. 2. A combined application of jus soli and jus sanguinis principles. 3. The legislative acts of state. 4. The voluntary act of the individual concerned. 2. Census of statelessness. De jure statelessness. A person has been stripped of his nationality by his former government without having an opportunity to acquire another. De facto statelessness. A person possessed of a nationality but whose country does not give him protection outside its own territory. Refugees. Statelessness occurs as a result of the following: deprivation of citizenship for any cause, example, commission of a crime. 2. Renunciation of nationality by express or implied acts. 3. Voluntary release from original estate. And 4. If born in a country recognizing only the principle of jus sanguinis, of parents whose law recognizes only the principle of jus soli. Conflict. Supra. Note: the Convention of the Reduction of Statelessness, adopted in 1961, mandates that the jus sanguinis country grant its nationality to a person born within its territory if he would otherwise be stateless, and the jus soli country to extend its nationality to a person who would otherwise be considered stateless when no one of his parents is a citizen of the contracting state. Stateless persons are generally subject to the law of their domicile or habitual residence, and in default thereof to the law of their temporary residence. Hague Conference of 1928 on International Private Law. Domicile or Territorial Theory. Lex domicili. The individual's private rights, condition, status, and capacity are determined by the law of his domicile. Adopted mostly by common law countries with population consisting of different nationalities, their unity may be achieved by adopting the law of their domicile. Domicile. It is the place wherein a person has a settled connection for certain legal purposes, either because his home is there or it is the place assigned to him by law. Domicile residence citizenship. Domicile is fixed permanent residence to which when absent one has the intention of returning. Residence, place of abode, whether permanent or temporary. Citizenship indicates ties of allegiance and loyalty. Legal classification of domicile. Domicile of origin. The domicile assigned by the law to a person at the moment of his birth. Minors. Legitimate. That of his parents at the time of the child's birth. If the parents are separated, the domicile of the custodial parent. Illegitimate. That of the mother of the time of child's birth. Legitimated. Domicile of father at the time of his birth controls, and the effects of legitimation retroacts to the time of the child's birth. Adopted child. Domicile of real parents at the time of his birth, not the domicile of the adopters. Foundling. Domicile is the country where foundling was found. Married woman. Married women. The right to decide the question of where the family domicile should be established is a joint prerogative of husband and wife. 2. Constructive domicile or domicile by operation of law. Domicile assigned by law to persons legally incapable of choosing their own domicile, like disabled, minors, and mentally disabled. Minors. Legitimate. The domicile of both parents in case of disagreement, that of the father, unless there is a judicial order to the contrary. Illegitimate. Domicile of the mother. In case of absence or death of either parent, the domicile of the present parent. Even in case of the remarriage of the surviving parent, still his domicile determines the constructive domicile of the minor child. Adopted. Domicile of choice of the adopter is the child's constructive domicile. insane, idiots, imbecile, they cannot select their own domicile. If the insane, idiot, or imbecile is below age of majority, rules on minors apply. Age and has guardians, followed domicile of choice of guardians. Does not have guardians, constructive domicile is his domicile of choice before he became insane. Married women. If the marriage is valid, constructive domicile of the wife is domicile of both spouses, unless the law allows the wife to have a separate domicile for valid and compelling reasons. If there is a legal separation de facto, the wife can have her own domicile. If the marriage is voidable, apply the same rules as when the marriage is valid. After annulment, the wife can freely select her own domicile of choice. If the marriage is void, as there is really no marriage, the wife can have a domicile separate from the husband. Other persons, convict or prisoner, he is not free to have a domicile of choice. His domicile is which he had possessed prior to his incarceration. Soldiers, since they are compelled to follow the dictates of the military, domicile is that before their enlistment. Public officials or employees abroad like diplomats, consular officials, and the like, since their stay abroad is in their official and not of their personal capacity, their domicile is the one before they were assigned elsewhere, unless they voluntarily adopt their place of employment as their permanent residence. Domicile of origin versus constructive domicile. Domicile of origin acquired at birth, assigned only to infants, never changes. Constructive domicile assigned after birth, assigned to persons under legal disabilities, may change from time to time. Situs or electric theory. The capacity, condition, or status of a person is governed by the law of the place, situs, where an important element of the problem occurs or is situated. Two kinds of participation of the individual concerned. Active. If the person acts voluntarily, the governing law is the law of the actual situs of the transaction or event. And number two, passive. When the effects of the acts are set forth or determined by law, the governing law is the law of the legal situs. Example, the domicile of the individual concerned. Domicile of choice of voluntary domicile, place freely chosen by a person sui juris as his home, and to which whenever he is absent, he intends to return. To acquire domicile of choice, there must be a concurrence of physical presence in the new place, and unqualified intention to make that place one's home. Domicile of origin, assigned by law. Constructive domicile, assigned by law. Domicile of choice, result of the voluntary will and action of the person concerned. General rules on domicile. No person shall be without domicile. Number two, a person cannot have two simultaneous domiciles. Number three, every natural person, as long as he is free and sui juris, may change his domicile at his pleasure. Number four, domicile, once acquired, is retained unless a new one is gained. Number five, the presumption is in favor of the continuance of domicile. The burden of proof is on one who alleges that a change of domicile has taken place. Number six, to acquire a fresh domicile, residence and intention must concur. To retain an existing domicile, either residence there or intention to remain must be present. To abandon a domicile, residence in a new place and intention to abandon the old place must concur. Renvoi. A procedure whereby a jural matter presented is preferred by the conflict of laws, rules of the forum, to a foreign state. The conflict of laws rule, of which in turn refers the matter back to the law of the forum. Remission, or a third state transmission. It is a French word which means refer back or return. In Anglo-American countries, the term used is remission, meaning to refer to the matter for consideration or judgment. It arises when the states are governed by the Nationality Theory on one hand and Domicile on the other hand. Remission or renvoi. Reference is made back to the law of the forum. Transmission. Reference is made to a third state. 4 ways of treating the renvoi problem. Rejection. Internal law solution. If the conflict rules of the forum refer the case to the law of another state, it is deemed to mean only the internal law of that state. Thus, the court will apply the foreign law. Acceptance. Single renvoi or single transmission. If the conflict rules of the forum refer the case to the law of another state, it is deemed to include the totality of the foreign law, internal law, and the conflict of laws rules. Thus, the court will recognize the referral back and apply local law. Number 3. Desistment theory. Mutual disclaimer of jurisdiction theory. The forum court, upon reference to another state's law, sees that such law is limited in application to its own nationals domiciled in its territory and has no provision for application to nationals domiciled outside of the territory. Hence, the local court will apply local law. This has the same result as the acceptance of the renvoi doctrine, but the process used by the foreign court is to desist applying the foreign law. Number 4. Foreign court theory. Foreign court assumes the same position that the foreign court would take if the case is litigated in the foreign state. Double renvoi. That which occurs when the local court, in adopting the foreign court theory, discovers that the foreign court accepts the renvoi. Transmission. The process of applying the law of a foreign state through the law of a second foreign state. Not the same as renvoi. Renvoi involves 2 laws, while transmission involves 3 laws. How to resolve renvoi problem in the absence of definitive laws on the matter. The theory to be adopted which, considering the circumstances of a given situation, will best result in fairness, equity, and justice. Personal status and capacity. Synopsis of the rules on status. Factual situation. Beginning of personality of natural persons. Age of majority. Use of names and surnames. Use of titles of nobility. Absence, presumption of death, and survivorship. Point of contract. National law of the child. Civil Code, Article 15. Lex Ferre. Kinds of capacity. Capacity to act. Power to do acts with legal effect, and juridical capacity, the fitness to be the subject or legal relations. In the determination of status and capacity of persons, our civil code follows the nationality principle when dealing with Filipinos. When dealing with aliens, it depends on which principle their country follows, but if the alien is in the Philippines, the nationality theory is applied by implication. A person's capacity to contract is governed by his personal law, whether it is the lex nationali or the lex domicili. The exception in the Philippines are contracts involving real or personal property, in which cases the lex situs or lex residendi applies. Family relations. Under the Civil Code, questions of family rights, duties, status, conditions, and capacity are governed by lex nationali. Marriage. Of all domestic relations, marriage is the most important. The validity of a marriage contracted in one state may be at issue in another state in cases of annulment, actions for support and custody of children, proceedings involving legitimacy of children, tax cases, divorce suits, inheritance problems, or criminal prosecution for bigamy. Marriage as a contract. Extrinsic validity, governed by lex loci celebrationis. Former requisites of marriage in the Philippine law. Family Code, Article Number 3. Letter A. Authority of the solemnizing officer. B. Valid marriage license, except in the cases provided for in Chapter 2 of the title. And A. And C. A marriage ceremony which takes place with the appearance of the contracting parties before the solemnizing officer and their personal declaration that they take each other as husband and wife in the presence of not less than 2 witnesses of legal age. General rules. All states recognize as valid those marriages celebrated in foreign countries as if they comply with the formalities prescribed therein. Hague Convention. B. The forms and solemnities of contracts, wills, and other public instruments shall be governed by the laws of the country in which they were executed. Civil Code, Article 17. All marriages solemnized outside the Philippines in accordance with the laws in force in the country where they were solemnized and valid there as such shall also be valid in the country. Family Code, Article 26. Exceptions. The following are void marriages in the Philippines, even if valid in a foreign country, were celebrated. When either or both parties are below 18 years of age even with parental consent. Family Code Article 35, Paragraph 1. Bigamous and polygamous marriages. Family Code Article 35, Paragraph 4. Mistake as to identity of a contracting party. Family Code Article 35, Paragraph 5. D. A subsequent marriage performed without recording in the civil registry, the judgment of annulment, or declaration of nullity, partition and distribution of properties, and the delivery of the children's presumptive legitimes. Marriage where either spouse is psychologically incapacitated. Family Code Article 36. And F. Incestuous marriages. Family Code Article 37. And void marriages by reason of public policy. Note, these exemptions put into issue the capacity of the parties to enter into the marriage and relate to the substantive requirement for marriage. Since the personal law of the parties, example, the national law of Filipinos, governs the questions of intrinsic validity of marriage between Filipinos abroad, the above enumerations are exemptions to lex loci celebrationis, precisely because they are controlled by lex nationality. Intrinsic validity, controlled by the parties' personal laws, example, either domicile or nationality. Intrinsic requirements of marriage under Philippine law, Family Code Article 2, legal capacity of the contracting parties who must be male and female, and letter B, consent freely given in the presence of the solemnizing officer. Marriage contracted outside the Philippines. The Philippines follow the imperative or compulsory rule, which means that a marriage formally valid where celebrated is valid elsewhere. Civil Code Article 117, Paragraph 1. And Family Code Article 26. Reason: when the parties choose a place as the loci celebrationis of their marriage, they are considered to have subjected all questions of form to the law of that place, and if valid there, it should be considered valid everywhere. Rules on extrinsic validity of certain situations. Proxy marriages. General rule: where permitted by the law of the place where the proxy participates in the marriage ceremony, they are entitled to recognition in countries adhering to lex loci celebrationis rule, at least insofar as formal validity is concerned. Note, Philippine law does not sanction proxy marriages, but if celebrated in a foreign state in accordance with the formalities prescribed by its laws, it may be recognized in the Philippines under the lex loci celebrationis. Common law marriages. If valid in the state where the parties cohabited while holding themselves out as a man and wife, it is given recognition in sister states which do not. Okay. That's none. I cannot read it. Plural marriages. If the parties, or at least the husband, is a Muslim whose religion allows plural marriages, it is believed that we would recognize up to 4 marriages of the same husband, or recognized by the Philippine Muslim Code of Personal Laws to protect the rights of the wives and children. Mixed marriages. Marriage between a Filipino and a foreigner abroad. If the marriage is valid under the law of one of the spouses, while void under the law of the other, we should uphold the validity of the marriage, unless the marriage is universally incestuous or highly immoral. Note, same rule as to foreigners who marry abroad. Number 2, marriage between a Filipino and a foreigner in the Philippines. Philippine law should be followed. Proof of foreign marriage. The existence of the foreign law on marriage is a question of fact. And number 2, the alleged foreign marriage by convincing evidence. Note, without proof of said requisite, the foreign marriage cannot be recognized in the country. Factual situation, point of contact. Celebrated abroad between Filipinos, lex loci celebrationis, without prejudice to the exceptions under Articles 26, 35, 145, and 6, 36, 37, and 38 of the Family Code, bigamous, polygamous, and incestuous marriage and consular marriages. Between foreigners, lex loci celebrationis, except if the marriage is highly immoral, bigamous, polygamous marriage, or universally considered incestuous. Mixed, apply above number 2 to uphold the validity of marriage. Between foreigners, celebrated in the Philippines, national law, Article 21 Family Code, provided the marriage is not highly immoral or universally considered incestuous. Mixed, national law of the Filipino, otherwise public policy may be militated against. Marriage by proxy. A marriage by proxy is considered as celebrated where the proxy appears. Lex locis celebrationis with prejudice to the foregoing rules. Marriage as a status is not a mere contract, but an inviolable social institution. Its nature, consequences, and incidents are governed by law and not subject to stipulation. Family Code, Article